Thank you very much, Minister. Deputy O'Callaghan.
Well, I welcome the opportunity to speak on this important debate, and at the outset can I say that Fianna Fáil will be supporting these resolutions. I also want to welcome what the Minister has said in terms of emphasising that there will be a review of security legislation. In fact, I think he said it is ongoing in his department. I think we need to look at the two pieces of legislation separately because they relate to more than simply the Special Criminal Court. If you look at the 1998 legislation that was introduced in the aftermath of the Omagh bombing, this House and indeed the Seanad decided that the provisions introduced in the Offences Against the State Amendment Act 1998 were of such considerable power that they should be renewed and reviewed annually by both houses of the Oireachtas. The reason for that is because the Oireachtas at the time recognised that these were considerable powers. It's also important to note, however, that the 12 sections that have to be reviewed each year, they're not all just about the creation of new offences. For instance, 3 of the sections under the 1998 legislation, sections 2, 3 and 4, are evidential provisions that make it easier to prosecute subversives that are before courts. There are, however, a number of new offences provided in the 1998 legislation, such as sections 6, 7, 8, 9 and 12. And when you look at section 14, it provides that those new offences under the 1998 Act are to be scheduled offences under Part 5 of the 1939 Offences Against the State Act. Now, a point that is made, and it's a good point, by persons who are concerned about the operation of the 1939 Act, is that they say it's outdated, it's an anachronism, and it needs to be updated. And there's some merit, I believe, in that argument. If you go back to 1939, you'll see that the Act was enacted in June 1939 because of the threat that then existed of a European war, which came to pass. In August 1939, the government of the day made a declaration under Section 35 of the 1939 Act, stating that the ordinary courts were inadequate to deal with the administration of justice in certain instances. And that declaration, which can be made under Section 35, existed from August 1939 until the end of the Second World War in 1946. Then we had a second declaration made by the government in August 1972. And that declaration was made because of the violence in Northern Ireland and the troubles that existed on this island. That declaration that was made in August 1972 still exists. And there is validity to the point that says that the declaration that's in operation for the past 48 years doesn't really reflect the state of threat from subversives that exists today, but rather it reflects the historic threat that existed back in the 1970s. Fortunately, in this country, political violence and terrorism has reduced significantly. The Good Friday Agreement was a great achievement of all politicians in this country, great achievement of my party, if I can claim some ownership of it as well. And the effect of it was that political violence on the island and terrorism on the island reduced considerably. One of the requirements of the Good Friday Agreement was that there would be a review of the Offences Against the State Act. A committee was established under the chairmanship of Supreme Court Judge Tony Hederman to review it. That review took place in the aftermath of the horrific Omagh bombing. So it wasn't surprising that that committee by majority recommended that the provisions should remain as they are because of the significant threat that was posed to the state by subversive organisations. Regrettably, I agree with the Minister that there are still subversive organisations in this country that we need strong legislation to deal with. I think we need to recall that Lyra McKee was murdered not that long ago by dissident Republicans. And the threat which exists is evident from the report that's been presented by the Minister when he says, I think there was 146 arrests under the provisions of the 1939 Offences Against the State Act, of which 40 were provisions relating to provisions enacted in 1998. So my view is that the 1998 Offences Against the State Act requires to remain in place, but I do think we need to look and review the anachronistic provisions that exist dating from declarations that were made in 1972. I don't think there can be any doubt that the greatest threat, criminal threat, posed to the people of this country at present isn't from dissidents or international terrorism, but it is from gangland criminals who murder children and who use children from disadvantaged communities to promote their crimes and to make vast amounts of money for themselves. It is for that reason that back in 2009, the Oireachtas enacted the Criminal Justice Amendment Act 2009. It provides for 4 new offences to deal with gangland criminals. In particular, it provides that individuals can be prosecuted for directing or assisting gangland crime criminal organisations. That legislation, in my opinion, is extremely important and it needs to be kept in place. And we can see from the report that's been put before the House by the Minister that there were 29 arrests under Section 72 of the Act and 43 arrests under Section 73. The Garda Síochána have had great success in recent years in prosecuting gangland crime because of the powers that the Oireachtas gave them back in 2009. Now, I am aware, and I would prefer if all crimes could be prosecuted in courts where juries would decide the outcome of serious criminal charges. But I have to recognise that we have a responsibility to ensure that we don't put ordinary citizens from the electoral register who make up the jury list in a situation where they would be exposed to a significant threat. If people don't believe me on that, I'd ask them to reflect on what Peter Charlton and Paul Anthony McDermott said in an article back in 2000 when they said it's expecting too much to expect citizens to sit on juries in gangland trials and face the prospect of intimidation or trickery. I know there are very many well-intentioned people who say, well, listen, can we not introduce mechanisms whereby the jury will be not identified, where they won't be able to be identified by the persons being prosecuted? That can be very difficult and can also give rise to potential miscarriages of justice. Any jury hearing a serious criminal trial must be assembled together. They must be in the same location as the judge. The reason for that is so that the judge can effectively supervise the jury, to make sure that everyone on the jury is paying attention to the evidence, to ensure that if you have some form of remote jury involvement, that jurors aren't off doing something else. That could lead to a miscarriage of justice. The reason why I think the Special Criminal Court is still necessary because of these gangland crimes is because it is so easy to be able to identify and follow a juror. If you go down at 4:30 to the Courts of Criminal Justice, you'll see people leaving the courts on their way home. Very many of them are jurors. It's easy to follow them. It's easy to identify where they live. The crime of embracery is an ancient crime, but it's the crime that is the crime of trying to nobble a jury, trying to corrupt a jury, trying to intimidate a jury. It happens, and regrettably we have seen in this jurisdiction that gangland criminals will murder children, they'll murder journalists, and they'll intimidate witnesses. So they will take any steps to ensure that a criminal prosecution against them can be disturbed. And it's for that reason that I think that we need to continue with the Criminal Justice Amendment Act 2009. I also think it's important to point out that this is not an academic motion we are talking about today. The deadline for the continuation of the offences in operation is, I think, Monday night at midnight. And if a resolution isn't passed by the Seanad by that stage, well, then the offences will no longer be in operation. That doesn't mean that people who previously committed those offences can't be held liable because they were offences at the time they committed them. But it does unquestionably raise a question mark over any prosecutions that are pending before the Special Criminal Court pursuant to resolutions, if no such resolution is made by the Seanad. I just want to conclude by stating as well, I've spoken to Martin Kenny. I'm going to listen with great interest to his speech. But if it is the case that Sinn Féin is going to support these motions, I just want to state I believe that is a significant and positive political development. Thank you.
Thank you, Deputy Callaghan.